Judicial independence and autonomy. The Supreme Court is a constitutional body. It cannot be abolished, nor may its membership or manner of its meetings be changed by mere legislation. Article 8, Section 4, Subsection 1. 2. Members of the judiciary are not subject to confirmation by the Commission on Appointments. Section 9, Article 8. 3. Members of the Supreme Court may not be removed from office except by impeachment. Section 2, Article 11. 4. The Supreme Court may not be deprived of its minimum original and appellate jurisdiction as prescribed in Section 5, Article 8 of the Constitution. Section 2, Article 8. 5. The appellate jurisdiction of the Supreme Court may not be increased by law without its advice and concurrence. Section 30, Article 6, from the case Fabian versus Desierto, 1988. 6. The Supreme Court has administrative supervision over all lower courts and their personnel. Section 6, Article 8. The rule prohibiting the institution of disbarment proceedings against an impeachable officer is not required, who is required by the Constitution to be a member of the bar as a qualification in office, applies only during his or her tenure, and does not create an immunity from liability for possibly criminal acts or for alleged violations of the Code of Judicial Conduct or other supposed violations. In Re Beraugo, Admin Matter Number 09219 SC 2009. 7. The Supreme Court has exclusive power to discipline judges of lower courts. Article 8, Section 11. The Ombudsman is duty-bound to refer to the Supreme Court all cases against judges and court personnel, so the Supreme Court can determine first whether an administrative aspect is involved. The Ombudsman cannot bind the court that the case before it does or does not have administrative implications. From the case Cawebes versus Ombudsman, 2001. 8. The members of the Supreme Court and all lower courts have security of tenure, which cannot be undermined by a law reorganizing the judiciary. Section 2, Article 8. 9. They shall not be designated to any agency performing quasi-judicial or administrative functions. Section 12, Article 8. Administrative functions are those that involve regulation of conduct of individuals or promulgation of rules to carry out legislative policy. Judges should render assistance to a provincial committee of justice, which is under the Department of Justice supervision, only when it is reasonably incidental to their duties. In Re Manzano, Admin Matter, 1988. 10. Salaries of judges may not be reduced during their continuance in office. Section 10, Article 8. 11. The judiciary shall enjoy fiscal autonomy. Section 3, Article 8. Fiscal autonomy means freedom from outside control. As envisioned in the Constitution, the fiscal autonomy enjoyed by the judiciary contemplates a guarantee of full flexibility to allocate and utilize their resources with the wisdom and dispatch that their needs require. From the case Bengzon versus Derlon, 1992. It recognizes the power and authority to levy, assess, and collect fees, fixed rates of compensation, not exceeding the highest rates authorized by law for compensation and pay plans of the government, and allocate and disburse such sums as may be provided by law or prescribed by them in the course of the discharge of their functions. In Re, clarifying and strengthening the organizational structure and setup of the Philippine Judicial Academy, Admin Matter 2006. The provision in the Charter of the GSIS, that is, Section 9 of RA 8291, which exempts from all taxes, assessments, fees, charges, or duties of all kinds, cannot operate to exempt it from the payment of legal fees. Unlike 1935 and 1973 constitutions, which empowered Congress to repeal, alter, or substitute the rules of the Supreme Court concerning pleading, practice, and procedure, the 1987 Constitution removed this power from Congress. Hence, the Supreme Court now has the sole authority to promulgate rules concerning pleading, practice, and procedure in all courts. From the case GSIS versus Caballero 2010. 12. The Supreme Court alone may initiate rules of court. Section 5, Subsection 5, Article 8. The separation of powers among the three co-equal branches of our government has erected an impregnable wall that keeps the power to promulgate rules of pleading, practice, and procedure within the sole province of the Supreme Court. The other branches trespass upon this prerogative if they enact laws or issue orders that effectively repeal, alter, or modify any of the procedural rules promulgated by the Supreme Court. From the case Estepona Jr. versus Lobrigo, 2017. Only 13. Only the Supreme Court may order the temporary detail of judges. Section 5, Subsection 3, Article 8. 14. The Supreme Court can appoint all officials and employees of the judiciary. Section 5, Subsection 6, Article 8. Judicial restraint. The judiciary will not interfere with its co-equal branches when 1. There is no showing of grave abuse of discretion. PPA versus Court of Appeals. If there is no showing of grave abuse of discretion on part of a branch or instrumentality of the government, the court will decline exercising its power of judicial review. From the case of Chavez versus Comelec, judicial review shall involve only those resulting in grave abuse of discretion by virtue of an agency's quasi-judicial powers and not those arising from its admin functions. Second, judicial restraint. The judiciary will not interfere with its co-equal branch when the issue is a political question. Even when all requisites of justiciability have been met, judicial review will not be exercised when the issue involves a political question. Francisco versus House of Representatives, 2004. At the same time, the court has the duty to determine whether or not there has been grave abuse of discretion by any instrumentality of the government under its expanded judicial review powers. This allowed the Supreme Court to interfere in a traditionally purely political process, that is, impeachment, when questions on compliance with the constitutional processes were involved. What are the guidelines in determining whether or not a question is political? From the case of Baker versus Carr, 369 U.S. 986, as cited in Estrada versus Desierto, 2001. 1. There is a textually demonstrable constitutional commitment of the issue to a political department. 2. Lack of judicially discoverable and manageable standards for resolving it. 3. The impossibility of deciding without an initial policy determination of any kind, clearly for non-judicial discretion. 4. The impossibility of a court's undertaking independent resolution without expressing lack of the respect due coordinate branches of the government. 5. An unusual need for unquestioning adherence to a political decision already made. 6. Potentiality of embarrassment from the multifarious pronouncements of various departments on one question. Appointment to the judiciary. What are the qualifications of the members of the judiciary? Justices of the Supreme Court and the Collegiate Courts RTC Judge, MTC and MCTC Judge. Citizenship, natural-born citizen. Justices of the Supreme Court and the Collegiate Courts, at least 40 years of age. RTC Judge, at least 35 years of age. MTC or MCTC Judge, at least 30 years of age. Experience. Judges of the Supreme Court and the Collegiate Courts, 15 years or more as a judge of a lower court or has been engaged in the practice of law in the Philippines for the same period. Experience for RTC Judge has been engaged for at least 10 years in the practice of law or has held the public office in the Philippines requiring admission to the practice of law as an indispensable requirement. MTC or MCTC Judge experience has been engaged for at least 5 years in the practice of law or has held public office in the Philippines requiring admission to the practice of law as an indispensable requirement. Tenure for justices of the Supreme Court and the Collegiate Courts, holding office during good behavior until they reach the age of 70 or become incapacitated to discharge their duties. RTC Judge, holding office during good behavior until they reach the age of 70 or become incapacitated to discharge their duties. MTC or MCTC Judges, tenure, hold office during good behavior until they reach the age of 70 or become incapacitated to discharge their duties. Qualifications of judges of the Supreme Court and the Collegiate Courts, RTC Judge, MTC or MCTC Judge. Under Section 7, Subsection 3, Article 8, person of proven competence, integrity, probity, and independence. Note: practice of law is not confined to litigation. It means any activity in and out of the court which requires application of law, legal procedure, knowledge, training, and experience. From the case Cayetano v. Monsod, 1999. In case of judges of the lower courts, the Congress may prescribe other qualifications. Section 7, Subsection 2, Article 8. Disqualification from other positions or offices. Section 12, Article 8. The members of the Supreme Court and of other courts established by law shall not be designated to any agency performing quasi-judicial or administrative functions. The Supreme Court and its members should not and cannot be required to exercise any power or to perform any trust or to assume any duty not pertaining to or connected with the administering of judicial functions. From the case Mercado v. Pasay Transportation Corporation, 1932. Judicial and Bar Council. What is the composition of the Judicial and Bar Council? Ex officio members. Under Section 8, Subsection 1, Article 8, 1. Chief Justice as ex officio chairman. 2. Secretary of Justice. 3. 1 representative of Congress. Regular members. Under Section 8, Subsection 1, Article 8, 1. Representative of the Integrated Bar. 2. Professor of Law. 3. Retired member of the Supreme Court. 4. Representative of private sector. Secretary ex officio, Section 8, Subsection 3, Article 8 of the Constitution. The clerk of court of the Supreme Court, who shall keep a record of its proceedings, is not a member of the Judicial Bar Council. In the absence of the Chief Justice because of his impeachment, the most senior justice of the Supreme Court, who is not an applicant for Chief Justice, should participate in the deliberations for the selection of nominees for the said vacant post and preside over the proceedings pursuant to Section 12 of Republic Act 296 or the Judiciary Act of 1948. From the case Famela Dulay v. Judicial and Bar Council, 2012. Appointment, tenure, salary of judicial and bar council members. Ex officio members. The position of the council is good while the person is the occupant of the office. Only one representative from Congress. Former practices of giving 1/2 vote or 1 full vote each of the chairmen of the House and Senate committees on justice is invalid. Any member of the Congress, whether the upper or lower house, is constitutionally empowered to represent the entire Congress. The framers intended the Judicial and Bar Council to be composed of 7 members only, intent for each co-equal branch of the government to have 1 representative. There is no dichotomy between the Senate and House of Representatives when Congress interacts with other branches. The lone representative from Congress is entitled to 1 full vote. From the case Chavez versus JBC, 2012. Appointment of regular members. Section 8, subsection 2, Article 8. The regular members shall be appointed by the President with the consent of the Commission on Appointments. Term of regular members is 4 years, but the term of those initially appointed shall be staggered in the following so as to create continuity in the council. 1. IBP representative, 4 years. 2. Law professor, 3 years. 3. Retired justice, 2 years. And 4. Private sector, 1 year. Power of JBC. Primary function: to recommend appointees to the judiciary, may exercise such other functions and duties as the Supreme Court may assign to it. Section 8, subsection 5, Article 8. Note: judges may not be appointed in any acting or temporary capacity, as this would undermine the independence of the judiciary. Supervisory authority of the Supreme Court over the Judicial and Bar Council. The supervisory authority of the Court over the Judicial Bar Council covers the overseeing of compliance with its rules. From the case Hardalasa versus Judicial and Bar Council, 2014. Supervisory power, when contrasted with control, is the power of mere oversight over an inferior body. It does not include any restraining authority over such body. From the case Aguinaldo versus Aquino, 2016. Procedure of appointment. The Judicial and Bar Council shall submit a list of 3 nominees for every vacancy to the President under Section 9, Article 8. Any vacancy in the Supreme Court shall be filed within 90 days from the occurrence thereof. Section 4, subsection 1, Article 8. For lower courts, the President shall issue the appointment within 90 days from the submission by the Judicial and Bar Council of such list. Section 9, Article 8. Note: the prohibition against midnight appointments does not apply to the judiciary. From the case De Castro versus JBC, 2010.